Hello, my name is Peter Berge with Minnesota Continuing Legal Education. I want to welcome you to this Small Firm Success video podcast. We're going to be talking about the ADA and the recent changes to the ADA, and I have with me today David Cossi, who is an employment law lawyer in the Twin Cities area here. David, in his employment law practice, offers a full range of employment law services. He concentrates in the area of employee medical conditions and leaves. David is also the owner and founder of Effective Employment Practices, LLC. The corporation provides legal advice to businesses and human resources department, in particular for developing employment law practices and procedures. Now, David, I suppose the first question on the ADA here is, what caused Congress to make these changes, to amend the Act?
Well, Peter, the primary thing that happened over the years is courts, in their interpretation of the ADA, became stricter and stricter in their interpretation of the definition of disability, the actual definition of disability. And what happened is it eventually got to the point where the U.S. Supreme Court said in order to have a disability, you have to have a medical condition that substantially limits a major life activity, but they interpret substantially limiting as severe. So the impact of the medical condition on the major life activity, walking, breathing, running, sleeping, whatever the major life activity was, it had to be a severe impact. And so you either had to be completely unable to perform the major life activity, or you had to have be severely restricted. And the EEOC itself developed a process by which they said it had to be a significant restriction. So you have significant restriction by the regulators, you have severe impact by the U.S. Supreme Court. And what happened because of that was very few employees who had medical conditions, even ones that you might think would qualify, were being denied by courts. And so courts would summarily dismiss, summary judgment, claims by employees. And over time what happened was employees just brought fewer and fewer claims because they weren't being successful. They're being summarily dismissed. And so a number of people who qualified under the ADA shrunk, and it was a very small group of employees. And so there was a lot of reaction by groups out there about this is too restrictive.
So how do the amendments address those issues?
The amendments do really make very few changes in terms of number of changes, but their impact is great. And what they do is the Act, the Americans with Disabilities Act Amendments Act, is one of the few laws that has act in it twice. And what it does is it expands the definition of disability by taking two parts of the definition. There's three parts of the definition of disability. You have to have a physical or mental impairment that substantially limits a major life activity. Well, you still have to have a physical or mental impairment, but the major life activities have been expanded, and added to them have been major bodily functions. So things like your immune system, your digestive system, those are now part of the definition of major life activities. So what you're looking at now is not the impact on an activity, but the impact on a bodily function. And so that has somewhat medicalized the issue, whereas before courts could look at this and on their own, without any medical input, make a decision about whether the impact on the activity was severe, was significant restriction. Now you really need a medical person, a doctor, whatever healthcare provider that falls into the area you're dealing with, to say, yes, this is an impact on a bodily function. And then the substantially limits has been relaxed. It now says, instead of severe or even significantly restricted, it's something less than significantly restricted. It's something the EEOC has to come up with their own interpretation of the direction the law has given them, but it's going to be something like materially affects, not significantly restricts. So you add that, now you just need materially affects, not significantly restricts or severely restricts, to an impact on a bodily function, not an activity. And many, many employee medical conditions, especially chronic conditions, are now going to qualify as disability. So if the number of employees that were covered before was this big, now it's going to be like this.
Well, David, what does a practitioner, and particularly a small firm practitioner, need to know about the new ADA?
Peter, there's really a major consideration that they should always keep focused on, and that is reasonable accommodation. Understand that many employee medical conditions are now going to qualify as a disability, which gives them rights under the ADA. They're now qualified individuals with a disability, and they have a right to reasonable accommodation if necessary. So, you know, reasonable accommodation, you can think about someone with carpal tunnel syndrome. I need a new tool. This tool doesn't work for me with my condition. I need some other tool. Things like that. How do you make their environment such that the medical condition is not a barrier to them performing the essential job functions? But for practitioners, I think the major issue that they want to focus in on is leaves of absence, time off because of their medical condition. And the bottom line here is they have a right to time off to recover from their medical condition if it qualifies as a disability. So how this impacts all of the leave policies of employers is rather dramatic. If an employer's leave policies have been, the employee has used up all their leave time, but they have a right to take time off under the ADA as a reasonable accommodation, they get that time. It supersedes your employer's leave policies. And so the interaction with the ADA now with things like the FMLA. The FMLA only gives you 12 weeks of leave per year. Well, this new change means many employees' medical conditions that are serious health conditions under the FMLA will also be disabilities under the ADA. And when that 12 weeks expires, they may have leave rights under the ADA. And employers need to understand that. So short-term disability, work comp, long-term disability, family medical leave, and then just all of your leave policies, you really have to be careful with.
It sounds to me, David, like a small firm practitioner might have to be worried about this not only in terms of advising their clients, but also in terms of running their own business.
Sure. If they have 15 or more employees, they would qualify under the ADA and would have to be very careful about these issues in their own businesses. Now, under the Minnesota Human Rights Act, you only need one employee, so however, you need to get to 15 before you have an obligation to reasonably accommodate under the Minnesota Human Rights Act.
Okay. Are there any other laws impacted by this new ADA amendments?
Yeah, and I've already mentioned the FMLA, and I think that's the primary one. The FMLA gives you a right to take up to 12 weeks a year off as medical leave if you have a serious health condition and you are incapacitated by that serious health condition. It's always been up until now that FMLA leave was rather easy to qualify for compared to the ADA. Most people didn't qualify under, most employees didn't qualify under the ADA because of their medical conditions. Most employees did qualify under the FMLA because of their medical conditions. Now you're going to have both. And you know, to add more complexity to the whole situation, the Family Medical Leave Act regulations have been amended. The ADA changes that we've been talking about take effect January 1st. The FMLA changes take effect 16 days later on January 16th. So issues like they've made a change to chronic health conditions. You have to have 2 visits within 30 days to have a chronic health condition. That's kind of oversimplifying it, but just for purposes of discussion. Okay, so you have to have 2 visits to a doctor within 30 days. Well, if you qualify under the ADA and you have a disability, well, then you don't need that to get the leave. And employers have to understand how these changes interact with each other. So there's a lot of impact and cross issues between the 2 laws.
Great. David, thank you very much for joining us today. I think that's going to be very helpful to a lot of small firm practitioners. Thank you all for joining us today. You can see this video and other videos as well as a lot of resources that are going to be helpful to small firm lawyers at our website, which is smallfirmsuccess.org. Thank you very much. We hope to see you again in the future.
Thanks, Peter.